Welcome to the 14th Annual Marion County Prosecutor's Office Community Justice Academy. We appreciate everyone for attending, and we're looking forward to another in-depth and engaging series. I'm Jennifer Joy, and I serve as the Deputy Chief of Staff at the Prosecutor's Office, and I have the honor of introducing these two speakers today. For those who are not able to be here in person, thank you for joining us on Channel 16 and YouTube. The Academy allows public safety agencies and the community to come together to have an important, real discussion about the issues that directly affect our community. We are proud to have these important discussions at our yearly event. One reminder, after tonight, you'll be 2/3 of the way to your 2024 CJA t-shirt. And now to our speakers. Prosecutor Ryan Mears brings vast experience to the office and a balanced approach to the criminal justice system. Prosecutor Mears was elected into office in 2019 and has championed reform and set new expectations for the criminal justice system in Marion County. After completing law school, he immediately began his career in public service at the Marion County Prosecutor's Office. During his 18 years as a deputy prosecutor, he has tried more than 100 jury and bench trials. He served as the office's chief trial deputy under Terry Curry prior to becoming prosecutor, and has personally handled many homicide cases. Josh Puryear has been a public defender for over a decade. He currently serves as the Assistant Division Chief of the Level 6 Division at the Marion County Public Defender's Agency. Prior to this role, Josh was a supervisor in the Major Felony Division. He was born in Virginia, but was lured from his home state in pursuit of his dream job, defending indigent clients. He is a Marcus Emery award-winning attorney, an award which is given to attorneys who show distinguished service to their clients and the profession. With around 100 trials, he has experience dealing with everything from misdemeanors to murders. Tonight, we'll explore one of the most important concepts when it comes to the criminal justice system. We'll examine the ins and outs of the right to be tried by an impartial jury. We'll do so by diving into a murder case Prosecutor Mears personally handled, where jury composition became an issue for appeal. After going over the case and what led to this issue, we'll discuss why this is such an important concept and in the utmost interest of justice. Before we get started, I want to provide a warning regarding some of the sensitive content that'll be seen and heard, including explicit language. Please save your questions for the end. We'll call upon guests, and I will repeat the questions for everyone to hear before the speaker answers. Okay, let's get started.
Hey. My name is Ryan Mears. I'm a Marion County prosecutor. It's so good to see so many people come back out here again. Thank you for coming and participating in our Community Justice Academy. We are grateful for everyone coming. I will try not to move too much as we are on Channel 16. So I will try to stay stationary, but also avoid using the podium. One of the things that really makes the United States of America so special is the right to a trial by jury, meaning that people from the community ultimately come in and make a determination as to whether or not someone is guilty or not guilty of a particular crime. But attached to that, that right only means something if you have the right to a fair trial, meaning does the jury reflect the community, which is ultimately going to make the determination as to your guilt or not. And something that is frequently stated, that is rooted in the Sixth Amendment of the United States Constitution, is you have a right to a jury trial by your peers. And so what does that mean? And we want to explore that concept a little bit through the backdrop of a homicide case that I actually prosecuted probably 7-8 years ago. Now, a couple of things about this case. Number one, it happened literally within a stone's throw of here. This event happened at 30th and Capitol, and there was a homicide that took place. And so the first part of this is we're going to kind of walk through the actual process of trying to figure out who was involved in this case, talk about the jury selection process, the actual trial, and then what happened with the appellate court when they weighed in on some of the choices that the prosecutors, the defense attorney, and the judges made throughout that trial. So with that, we're going to get started. So right here is a map of the area right around the Children's Museum at 30th and Capitol, and there's a couple of dots on here. So what happened basically this time of day, this time of year, Some 7, 8 years ago, there was a homicide that took place. And there were multiple shots that were fired. We had multiple crime scenes. And just to orient everybody, this is Illinois, this is 30th Street, this is the Children's Museum right here. And what happened in this particular circumstance is in this alley right here, there was a disturbance. Multiple shots were fired. The person who was involved in that disturbance actually ran to the Children's Museum and got help. Their vehicle was shot up, they got help from the Children's Museum, but the tragedy here is that person went back to that scene because he wanted to get his car. Now keep in mind his car had just been shot up, he has an additional confrontation with the person that he was fighting with. He runs in this direction across 30th Street, and as he's crossing 30th Street, he is shot multiple times. And he runs right to this area right here, which is a nursing home, where he tragically passes away. And so the only information that we had the night that this homicide took place is we had information that there were multiple shots fired runs. We knew who the decedent was, and we had a 911 caller who provided a little bit of information about what took place. I'm going to play for you the first 911 call.
Hey, they are right here on 30th, right here on the light. You hear gunshots? You in the outlane other than they're up there shooting. Right here, I made 30th and Capitol on this light.
30th and Capitol, are you north or south of 30th?
It's right here on the corner, I don't know, it's right here on the corner, right across from the liquor store, on the light, come up. You get on the outlane hoodie. You get on the light, and he's shooting out there, he's shooting, boys, we just get up here now. Goodbye.
What, I need?
All right, so I'm going to stop you right there. For those of you who couldn't hear, this is what she said. She said they're up here shooting right on the lot at 30th Street. He said, is it north or south of 30th Street? She said right next to the liquor store, which is right here, Vicky's Liquor. And she makes that call and she gives a description of the person involved. She says they are wearing a white sweatshirt. So at this point in time, IMPD, when they respond to the scene, don't have a ton to go on, but they're looking for someone with a white sweatshirt, and lo and behold, they stop somebody with a white sweatshirt by the name of Adrian Durden. And then, but unfortunately, the police didn't have much to go on, so they cut him loose. And then we have a second 911 call.
Hey, the dude just got shot. The dude shot him, it's over here in this alley.
So somebody got shot?
Yeah, and the dude shot him down our light.
Okay, how come you didn't tell me that 7 minutes ago?
Look,
That was very useful information.
I didn't get off the phone, because they come in there.
So we have a 911 caller who says and indicates, I saw the shooting. The person who did the shooting is up here on scene. So police respond, they spot someone who kind of matches a very general description, not much there, and they take a preliminary statement, and the person says, I don't know anything about anything, and they ask about the car that is shot up. They said, do you know anything about this car? And the person says, absolutely not. Did you ever touch this car? Absolutely not. Were you ever involved with this car in any way, shape, or form? I've never seen that car before. And so from there, the police process the case and begin the investigation. And so what do they have? So right here is the car that was shot up, that is in that lot that I saw, you saw just on that map. You can see that the windows of the vehicle are shot out and that we have bullet holes right there. What is on the ground that is marked, those are known, what are commonly referred to as shell casings. And shell casings, when you fire a gun, they will eject part of the projectile or the bullet. And that's what the police are marking on the scene there. So you can see we have a number of shell casings right there. We can see the damage to the vehicle. There's maybe a better picture of what a shell casing looks like. And then that's the nursing home where the person ultimately passed away. And right here you can see that there are additional shell casings that are marked on the other side of 30th Street. So one of the first things that we're trying to figure out is we want to make sure, how many weapons do we have? We have multiple shell casings. Are all of these weapons fired from the same firearm? So we go in, we test all of those things, and we very quickly realize that all of the shell casings come back to a single firearm. They're all related, they came from the same gun. So we know we're just looking for one gun. This is the nursing home. Our victim actually ran towards the nursing home. He's trying to get help after he's been shot. They let him in. They try to offer assistance, but unfortunately, he passed away right there at 30th and Capitol. So law enforcement doesn't have a ton to go on right here, but they know that they're looking for a witness. They're looking for that 911 caller, but they don't really have any identifying information about this particular 911 caller. And then, as is often the case, we kind of get lucky and we catch a break. And somebody says, there's a woman who saw what happened, and her name is Kiki, okay? And so we then begin looking for Kiki. Where can we find Kiki? And so we're scouring police reports, we're talking to people who live in the area, we're talking to people who are maybe on the northwest side of town. Does anybody know anybody by the name of Kiki? Because we know that the person who made those 911 calls saw the shooting, knows what happened, knows what took place, and can probably identify our shooter. So that is what we are trying to figure out. And so what happens is we hear from a detective, not a homicide detective, but a drug detective. And so there is an IMPD narcotics detective who is doing an undercover drug buy. And during the course of that undercover drug buy, they are in the area of 30th and Capitol. And as they're talking in the area of 30th Capitol, she volunteers that her friend just got shot and killed over a dice game. And so what you're looking at right here, the undercover police officer is driving the vehicle, and they have a hidden recorder that is recording both audio and visual his entire conversation with a person that he knows as Kiki. And so they are having the conversation. She volunteers as they're driving around the neighborhood. Hey, they just shot my friend. I think Wessler's going to play a little portion of the video. So this arm you see right there extended, that is the undercover police officer. And he is with Kiki as they're about to do a drug deal. So as you can see, they're sitting there, they are talking, and because I don't want to necessarily tell exactly who Kiki is, I'm just going to play the audio for you now.
Thank you, but this ain't what I want. It's more. No, I gotta go around the corner.
Let me take you back over to the spot.
I'm gonna get going in the front, in front of the street, in front of my room. Turn right.
Who killed your dude? You know who did it?
Yeah, I was standing right there. The guy I grew up with, named Didi.
Who did?
This guy named Didi I grew up with.
Dee Dee?
And they were shooting dice, and my guy won $5 off of him and quit, and he got pissed off. But he had to leave. He had to go pick his wife up from work. So I left.
You didn't get a chance to win money back, did he?
No, my guy won.
Oh.
The other guy got shitty because he wouldn't keep playing, so he wanted $5 back. But the other guy, excuse me, you got to 2 lots of money in your pocket like this. You don't man. The you took him for $5. You tripping. I don't like this stuff.
He ain't up here down anymore. I don't want to be up here if he's up here.
No.
Turn right?
Yeah.
All right, so that wasn't super clear, but basically what was stated during that is she volunteers that she saw the shooting, that it was over a $5 dice game, that he lost during the dice game, and that he basically shot him for no reason. And he asked her point blank, do you know who did it? And she says, yes, it was Dee Dee, a guy I grew up with. So the detective involved with this undercover buy has kind of a dilemma. He's got a bit of a problem. He's an undercover officer. He's an undercover detective. And we don't necessarily want to blow his cover, but we also need to figure out and solve this murder case. And so from there, he contacts the homicide detective who contacts the prosecutor's office, and we begin a discussion about how can we bring Kiki in and have a conversation about this homicide. And I will tell you, she was a less than enthusiastic witness. Her initial response was basically, I was drunk, I was high, I don't remember anything that took place on that day. But eventually, we were able to get her to the position where she was willing to share with us a little bit about what took place. And she more or less told us what she told us in the call, or what was in the undercover video, that she was in fact there. She corroborated that she was the person who was the 911 caller, that she was the one who called 911. We were able to link up a phone associated with her with the 911 call. And then we were able to demonstrate that, hey, we have reason to believe her because we have her voice on recording at the 911 call, placing her at the scene. The other issue that you have in a case like this is when she is testifying, when she is talking about this, she has no motive to lie at this particular point in time. She is literally in the midst of a drug deal with someone she believes to be her friend. There's not really much motive to lie there. And so she shares and says, this is what took place. Now, for us as a prosecutor's office, this can be a challenging case because we know we have a reluctant witness. And we have a reluctant witness who has a terrible drug problem, who is going to testify that, yes, they were under the influence of those drugs at the time they saw this event take place. And the only reason we know that they are a witness and we were able to identify this person as a witness is because they were buying and selling drugs. So not exactly your most ideal witness. And then when you add on the additional layer, she didn't want anything to do with this process. She didn't want to be a witness. She didn't want to testify. She didn't want any part of this. And so as the prosecutor on the case, this presents a lot of challenges because it's essentially a single eyewitness case. We have a single eyewitness who's going to tell us what happened, who struggles with a lot of different issues and demons. Are we going to be able to get this person to trial? So, but we make the decision, we file the murder case. And we file the murder case, and when we file the murder case, we know that we are buying ourselves a trial because there's a lot of extenuating issues and circumstances with this case and with this witness. All right, so this brings us to our concept and our conversation about a jury of our peers. What does that mean? Remember, jury of our peers, it comes from the 6th Amendment of the United States Constitution. What does that mean? What does that look like? For those of you who don't know, that is Denzel Washington playing Reuben Hurricane Carter, who was falsely convicted of murder. And they reference the 6th Amendment guarantee to your right to a jury of your peers. Go ahead.
All rise. Court will come to order. The Honorable Judge Larner presiding.
Be seated. The defendants will rise. Reuben Carter, although you still contend you are not guilty of the crimes charged against you, you were afforded a full and fair trial by a jury of your peers. Have you reached a verdict?
Yes, we have, Your Honor. We, the jury, find the defendants, Reuben Carter and John Artis, guilty on all counts.
Order in the court. Order. The bailiff will see to it that order prevails.
Okay, so this is going to bring up a discussion of what does a jury of your peers actually mean and what does that constitutional provision actually include. And I want to bring Mr. Purrier in from the Public Defender Agency to help us through this discussion. And so I think the first thing is just to know who is able to serve on a jury. And the qualifications are not much. You must be a citizen. You have to live in the county. You have to be able to read and understand the English language. You can't be under guardianship. If it's a criminal case, you cannot be a police officer. And so there's a really pretty basic provisions in terms of who is allowed or qualified to sit on a jury. And then from there, we try to pick a jury. So usually what happens is a bunch of people get summons, not many of you guys actually show up, and then we have 40 or 50 people sitting there, and we're trying to get to 12 jurors plus 2 alternates. And then we, the attorney, have the ability to strike people for cause challenges or preemptory challenges. So there's 2 different ways you kind of whittle that jury pool down to your 12 jurors. And so I guess for cause challenges, what are you looking for when you talk to jurors? What type of things are you looking or spot to find someone who maybe should be struck for cause? What does that mean to you, and what's the practical implication of that?
Well, I mean, for cause challenges, essentially, there are people who can't be fair and impartial, kind of by default is kind of how I look at it when I'm doing for cause challenges. A lot of the times, it depends on what the actual case is. If it's a robbery case, I can look at the jury questionnaire and see if someone's had some prior interactions with robberies, like if they've been witnesses or if they've been victims of robberies. You kind of get it in your mind that that person may not be fair and impartial for a robbery trial. Or, if they've had, some people explicitly say they can't be fair and impartial. In fact, one of my favorite jury questionnaires when I was picking a jury for a serious violent felony case, the person said that I don't like minorities and bigger women. My co-counsel was a little bit bigger, and she looked at me and she said, "Looks like we're both screwed." But a lot. It kind of depends on the case. I would say people can be fair and impartial, and it comes out through the voir dire process, or when you're asking jurors questions about how they feel about certain things as well. So I think those are, your question is what you look at initially, and then you kind of listen to what they're saying in terms of, their answers to your questions.
And when you go through the for cause process, walk me through what types of questions you'll ask someone when there's for cause, where you can go to a judge and say, "Hey, I don't think this person legally can sit on this jury."
Oh, well, I'm usually very nice about it. I'll come and say, "Hey, I see in your questionnaire that you have this particular thing. You had a robbery. You had a robbery happen to you some years ago. Are you going to be thinking about that while this trial's going on? Do you think you can put that out of your mind?" Ultimately, you have to get to the point where you ask them kind of, even if the judge tells you you have to be fair and impartial, can you be fair and impartial? You want to get to that point because some judges will not give you the for cause challenge if you don't get explicit to that point. So you want to get at least as close as possible to that person saying they can't be fair and impartial. That way you can go up to the judge and say, "Judge, you heard what that person said. They can't be fair and impartial. They got this, their uncle was a victim of, being shot. This is a shooting case. It's going to be on their mind. They can't be fair and impartial, judge. So try to explain some cause."
So my dad was actually summoned, and he came down for a jury in Marion County. It was a criminal case, and they said, they always asked, "Do you know anybody?" He said, "Yes, I know Ryan Mears, that's my son." And he goes into the box, and they said, "Do you think you can be fair?" He said, "I think I can be fair to my son." And so there we go. So he was struck for cause.
I've actually had one time where I had my client's father on the jury panel. Because I was reading the questionnaire, I was like, "Wait a minute, that's your mom's name." I was like, "Wait a minute, that's your dad." And the judge quit before he came in, unfortunately for him. He wanted to see his dad, but whatever.
And then we have something called peremptory challenges, where you're able to strike people basically for any reason, as long as you have a race-neutral reason. So I can't strike someone because of their gender or their race, but I can strike them for any other reason. If I can say, "Man, I'm going to strike you because I don't like people in red shirts," no one can stop that. It's something that is 100% available to both the defense and the state. In a major felony trial, you get 10 preemptory strikes. So as you go through the process, you know that I can strike 10 people for any reason, as long as I have a race-neutral or gender-neutral reason for who I am striking and why I am striking them. You've certainly exercised these challenges in the past. What are you looking for when you're utilizing those peremptory challenges? What are you trying to do?
Well, when I'm exercising my peremptories, I'm looking for people who just don't agree with my assessment of the case, like my defense. When you're picking a jury, especially, well, as a defense attorney, you know, you want to know if the jury can listen to what you're saying and at least consider what you're saying. You know, they're not necessarily going to agree with you all the way, but you want to have a jury that can sit there and listen to what you're saying and, you know, not, you know, basically say, this dude's full of it, I don't believe any of this. You know, you want to have a chance, basically. You want to have a chance at you know, a positive outcome for your clients, you know, in your challenges. And of course, you know, you want the best jury for your client. That's the long and short of it.
Yeah, and one of the things that I'm always trying to do with my peremptory strikes is I am just basically trying to find who are the crazy people. I am looking for crazy people that I can get off the jury, because at the end of the day, you're going to tell, hopefully as a prosecutor, a very rational story. This is what took place. These are the objective things that we should point to hopefully hold this person accountable. And so what I'm trying to do is I'm trying to find the people who are maybe out there a little bit, who maybe have a little bit different perspective, or someone who maybe doesn't necessarily have the right level of life experience to handle a case. And so in the case that we just talked about, one of our main issues was, how are people going to feel about someone who uses and abuses drugs? And how are people going to feel about how that's going to impact their ability to recall things? Are they going to judge that person? Are they going to say this person's not credible because of the drug use? And so in voir dire, we spent a lot of time talking about that issue, about how witnesses aren't perfect, how witnesses sometimes bring certain issues with them into the courtroom. Are you okay with that? How do you tell if someone's telling the truth or not? What would you rely on to try to figure out if someone's telling the truth? And if we didn't like the answer, or if people wanted, you know, witnesses who were, if they were looking for a bus full of nuns to be the witness, this was not the case for them from our perspective, because we knew that we were going to present people who had some very interesting backgrounds, and we're going to present in a way that maybe not everybody understood, or lived a lifestyle that a lot of people couldn't appreciate. And so, you know, remember, as prosecutor, you're always thinking about the victim. You're thinking about the victim who lost their life, you're thinking about the victim's family, and you're thinking about bringing justice to that family. How can you do that? And so you want people who are going to have an open mind and be willing to listen to people, even if maybe they did things that you don't understand, or think, hey, how could someone possibly do this? So that's how we whittle the jury down. But one of the questions is, what does the law guarantee? We have that scene from the hurricane where they kind of flash over. And what it says is, this is coming from a couple of United States Supreme Court cases, the Sixth Amendment requirement of a fair cross-section of the veneer, which is the jury pool, is a means of or assuring not a representative jury, which the Constitution does not demand, but an impartial one, which it does. A defendant is not entitled to a jury representative and proportionate of every age group or ethnic group or educated or non-educated group in the district in which the trial is held. A criminal defendant has no affirmative right to a jury of a particular race, gender, or age composition. And so what this really means when we say a jury of your peers and who ultimately ends on a jury, the protection is in terms of how we get people to come in for jury service. Was that process flawed? What did we use to bring folks in to jury service? And so what happens in the state of Indiana is that Indiana Supreme Court sits down and they compile a list using a bunch of different databases, using a bunch of different categories to make sure that we have a fair cross-section of the community is summoned to come in for a jury. Who actually answers that summons and who actually appears, that's another question, and that's another discussion. But the idea is the process in terms of who we are reaching out to has to be fair and has to reflect the community. So what you cannot do is, you could not say, hey, we're not going to summons anybody from the south side of Indianapolis. You can't do that. Kind of the most famous case legally is there was a case involving women, where women were excluded from serving on juries. They were not a part of the jury pool. And so the Supreme Court said, no, you can't do that. That's not a fair cross-section of the community. And then they changed it. They said, aha, we got you. Women have to opt in to serve on a jury. And then the United States Supreme Court said, nice try. No, they have to automatically be included in the selection process in terms of who's allowed to serve on a jury. So that's what the Constitution requires. And I guess my question for you is, you and I both primarily practiced in Marion County. And so as you sit here, understanding this Sixth Amendment requirement, and this, I guess I'll let you tell the story as well. There are going to be times when you look at the jury pool and it doesn't always reflect the diversity of the city of Indianapolis. Just to throw out a couple of facts for you, Marion County is, for the first time ever, predominantly non-white. If you showed up and you looked at our jury panels, would it be predominantly non-white?
It would 100% be predominantly white. I've done, like I said, about 100 juries. Most of them have been mostly white. I think actually my last year I did was probably the biggest, the best mix of jurors I've ever had. So yeah, it's definitely not an accurate cross-section as well.
And how do you as a defense attorney, what are the conversations that you'll have with your client about those issues, and does that concern people that you represent?
It does. Like my clients of color, obviously, I want to see some representation for them, in the veneer. We have that conversation, and I usually will tell my clients that, look, it's not necessarily what they are, it's what they say, but, obviously deep down, I do wish more people of color would show up for jury duty, but I usually, kind of allay my clients' concerns by saying, we're going to ask some questions, we'll get it out there, we'll get our story and our idea out there and voir dire and see who can listen to us and, kind of, be on our side about things. So, but yeah, absolutely. I would say most of the time it's definitely majority white.
And I just want to talk about the process of who shows up. So for those of you who have never had the opportunity to serve on a jury, we, the lawyers, are sitting there, we're waiting for you, we're anxiously anticipating your arrival. You come in, you fill all the seats in the courtroom, you try not to look back, but then you have to because you want to know what does this group look like, because we don't have any racial identification information at all. We don't know until we see the jurors walk in. And so when you turn around and look and see who's ultimately come in, is it 51% non-white?
No, it's not. It's definitely not. It's usually the majority of white people, which, I'm used to it by now, but yeah, it's not, I will tell you when it's a difference. I'm like, oh man, we got some different people in here today. It's noticeable when it's not, majority white people. It just is.
And do you ever try to address race subtly or implicitly or even directly during the jury selection process?
It depends on the facts of the case. Sometimes it's hard to hide. I'm a black attorney. I will say again, sometimes you get people who on their questionnaires will say certain things. Well, I guess I will give it as an aside to you. I've had people who have put that they don't like people of color. I've had prosecutors actually before I get there kind of hammer on the people who say things like that. So, but yeah, it's definitely something that you think about, you consider.
And and this is going to be on Channel 16, which is probably a bunch of civically engaged people. I mean, I think the thing to remember is when you get that jury summons, it's one of the few things that our country asks of you. It is an obligation, and when you show up, or more importantly, when you don't show up, it throws the entire system out of whack. And so the only way we are going to get a representative cross-section of people is if everybody responds to their summons. And if you don't respond to your summons, then the jury pool is not going to reflect the community in a way that I think represents us in the best way possible. And so at some point in time, you're going to get a jury summons, and when you get that, and they ask you to come in, please come in. And when you come in, don't write on your questionnaire, Ryan Mears is my best friend. I could never sit on a jury, which people do. But make sure you are fair and impartial and hear the facts out, because it really is important and it is necessary for us to be able to conduct the criminal justice system. This week alone, we'll probably have anywhere from 10 to 12 juries going. We have 3 separate murder trials going right now. And then through the course of the week, we're going to have a variety of other cases go. And we can only do that if people show up. And so we know we're asking a lot of people to give us a couple of days, but it really is important in order for us to kind of fulfill our constitutional obligation and make sure the jury pool reflects our community.
I had a question. How many of you guys in here have been on the jury. Okay, so we got a good amount of people.
Okay,
You've got-
what color are we though, right?
Fair, fair. What was your experience?
Well, it was all white,
Fair.
and it was many years ago. I felt privileged to be able to do it, and I felt it was my obligation to do so.
So it's not that bad, I guess is what I'm getting at.
The case I was on wasn't bad, but my father served on a murder case many years ago, and he never recovered from it. It was the death of a child. Yep.
Yeah, those are incredibly tough cases.
Yes.
So in State of Indiana versus Adrian Durden, we are able to pick our jury. We have our jury. We are sitting there, and it's state, call your first witness, and our first witness is Kiki, and she is nowhere to be found. She declined to participate in the process. And like your jury summons, if you are served to be a witness, in particular, if you're a witness on a homicide case, I always tell people, this is not an invitation, this is an obligation. And if you don't want to live up to that obligation, unfortunately, we're going to have to bring you in. And so she was arrested on a bench warrant, and she was brought in front of the Judge Grant Hawkins, and we said, what are you going to do? And she said, I'd rather not participate, I'm not saying anything. And so the way that works is, we put you on the witness stand, the judge asks you a couple questions, I asked a couple of questions, this is all done outside the presence of the jury. But the judge asked her and said, hey, are you going to answer the questions? And she said no. He said, awesome, I'm going to hold you in contempt. Deputies take her to jail. I'm going to sentence you to 180 actual days in the Marion County Jail for not participating in the process, which he did. So for us at this point in time, we have a couple of pieces of evidence we can use. And not to get too far into the weeds, we have a prior statement of identification from her. She sat for a deposition where she kind of told a similar story. So we have prior statements that we could get in, we could play that video. So we said, hey, we're still gonna move forward, we're gonna go to trial. As I initially told you, the police stopped Adrian Durden that night and they say, hey, what do you know about that car? Do you know anything about that car? No, never saw it, never touched it, never even been around it. I don't even think I've even looked at it. There's no chance. And what do we find? Of course, we find his fingerprints on the car. Which was a pretty helpful fact. So we've got this video, and we're gonna move forward with the trial, and we did. So we moved forward with the trial. Fast forward to day 3 of the trial. Kiki says, "You know what sucks? The Marion County Jail. I'd like to reconsider my position that I'm not going to testify." And we say, "Great." And she comes in and she testifies. Now, keep in mind, she is now going to be cross-examined about her drug use. She's going to be cross-examined about the fact that she didn't really want to be here. She'll be cross-examined about the fact that she's currently sitting in jail because she didn't want to be here. But she did come forward and she told her side of the story and what she remembered. And so we were helped by a couple of things. Number one, she had a long-standing relationship with this person. This is someone that we knew, that we proved that she knew from the neighborhood. That was a good fact. Number two, we had her 911 call. And so she had her 911 call so we could place her at the scene. Cell phone records don't help us in this case because Adrian Durden lived in the area. So we already knew his cell phone was going to put him in the neighborhood. That doesn't help us. It's not going to do, you know, he's going to say, I live there. Of course, my cell phone comes back to that area. And so we were relying on the 911 call, and we were relying on the video with the undercover officer where she said that it was her friend, or it was Dee Dee, who did this. And then, of course, we had his fingerprints all over the vehicle that he had never even seen, let alone touched, that belonged to the victim, who was the victim of the homicide. And so fast forward, we go to trial. And we go to trial, we present all of this evidence, and it's time for deliberations. And during the course of the deliberations, an issue comes up with one of the jurors. And the juror is struggling, she does not really want to be there, and she says, I'm out. Can't do it, don't want to do it. This case happened some time ago, but I think there was kind of long-standing issues where maybe this juror was not expecting to be picked, and then when she was picked, wasn't super excited about it. And so the judge has a conversation with her, and the judge says, I think we need to strike this juror. We need to remove this juror. But this juror was African American. And the judge was also African American, great judge, Judge Grant Hawkins. You practiced in front of him for a number of years. I practiced in front of him. Great guy, great judge, always concerned about fundamental fairness. And so what he said was, he said, I'm going to excuse this African American juror, but we are not having an all-white jury decide this case. And so the first alternate was white. The second alternate was black. And he said, I'm going to skip the first alternate, and we're going to go with the second alternate, who's African American. And so that's what happens, and the verdict comes back, and it's a verdict of guilty. And the defendant is found guilty. And so, you go through jail phone calls, you get additional evidence, you get a bunch of other things. We were very fortunate that our case was getting stronger as the days went by, but nonetheless, he files an appeal. And in that appeal, the Indiana Court of Appeals says this case is getting reversed because what the judge did was unconstitutional because they skipped over the white juror. And I think the opinion says something, no matter how noble the intentions might be, but they made the decision, they said, we're skipping over the white juror, you can't do that. And they said, we are going to reverse this and remand this back to the trial court and state you have to try this case again because we don't think it was appropriate to skip over the white juror. Now, keep in mind, the prosecutor, the defense, and the judge, we all agreed. We all said, we agree, Judge. We do not think an all-white jury should decide this case. And so we had that conversation. That conversation was on the record. Nonetheless, the Indiana Court of Appeals reversed us. So we have a real-life defense attorney who practiced in the former Criminal Court 5. You have to make a lot of tough choices and a lot of tough calls when you are in the middle of trial. And so I have a question for you, and you were not the attorney on the case, but a question for you, when you're sitting there and you have a situation like this, how do you approach it when there's kind of the legal concerns, but there's also the pragmatic concerns, and there's also the concerns of your client? How do you weigh all of that and making a decision as to whether or not you would agree to something that maybe doesn't fit the letter of the law, but certainly satisfies the spirit of the law?
Oh boy, this would have been a good call. I mean, you'd have had, in my mind, you have to weigh kind of a lot of things, I will tell you, I probably ultimately would have agreed as well to doing it that way, but you got to look at it from kind of how's the trial going, what do you think of that particular alternate when you were picking them? What do you think of the alternate that's skipping over? You have to weigh kind of all of these things, and you don't get a long time to do it, or at least it doesn't feel like a long time. But at the end of the day, I think it would probably be more, of a feel situation for me, just in terms of how it, ultimately would, my decision would be. That's what I would say.
And when you have a conversation like this, how much do you rely on what your client is thinking? Your client is sitting next to you, they're watching the entire trial, they're observing the body language of the jurors, the demeanor of the jurors. How much do you defer to your client in a situation like this?
I would say very heavily. I mean, I definitely say, like, what's going on? Here's the situation. What do you think? I mean, I probably would leave it up to him. I mean, and I think it would depend on the particular client. They may have faith in me to kind of figure it out, but I would definitely have a conversation with them about how I'm thinking about the whole situation. And again, I think it would be a tough call.
One of the biggest things that we as trial attorneys always have to keep in mind is we have to make a record for what people are going to rely on in the future for the Court of Appeals or the Indiana Supreme Court. What record would you try to make and why when you're making a tough choice like that? And you're also, as defense attorney, you also know that there's a potential PCR down the road.
Yeah.
Because it probably, there's probably something somewhere that says you can't do that or you shouldn't do that. How do you weigh all these different competing interests, and what sort of record are you going to try to make to the trial court?
Well, I mean, I will say, as a defense attorney, I normally don't necessarily think about PCRs. I'm not like, if I do, PCR basically is a way for, it's a collateral attack, if you will. It's a way for your client to do kind of a limited appeal on some issues that happen during trial or during representation. I don't necessarily consider that because when I am doing the case, I don't I don't disregard what my clients thinking and ideas are in the case in the first place. I will have a conversation with them about the whole situation. As far as records go, the record kind of would have been laid kind of as to what the situation is in terms of the juror needing to leave, and I think those things would have happened. I probably would have objected to the juror being, removed. It kind of would depend on, again, how it's going, how, I felt about that juror in the first place, how I feel about this juror now. So I probably make that record first, but then in terms of the alternate, I would say, I would try to follow it logically, just like how the judge did, actually, in terms of saying the makeup of the jury and kind of going at it from that angle.
And you said how you feel about the juror. Now, just to be clear, we don't get to talk to the jurors. We get a little bit of insight into what the jury is thinking based on the questions that they ask. And so when you say if you like the juror or not, what things are you talking about? The questions they ask, the body language that they are projecting, how they react to certain pieces of evidence? What are you, when you say if I like the juror or not, flesh that out for me a little bit more. What you're looking for to assess the juror?
Absolutely. It would be how we were engaged in voir dire. When I'm talking to them doing voir dire, what the prosecutors getting out of them as far as information. How they're reacting to photos, testimony. Are they taking a lot of notes? Do they seem to be actively engaged in the process? If they've asked questions, because normally if a juror asks questions, you'll at least have what juror number they are. So you can get kind of an insight into that person's mind from that aspect of things. And again, sometimes it's just a gut feeling. You look at them and you're like, I was having a good vibe about this person, during the selection process. I think it's still there. I'm looking at them. I guess that's kind of what I mean. It's kind of totality, of the process, if you will, like how things are, how they've been. So.
And we've both been fortunate enough to try a bunch of cases, and I cannot stress this enough. All of us have gone through jury trials. We've gone through the jury selection process. You are out of strikes, and you're like, oh my gosh, I hope this person is not on the jury, and they are, for whatever reason. And so a lot of times, you're getting a jury where you don't necessarily love all 12 people.
Yeah.
Because you ran out of strikes, and you couldn't get someone struck for cause. And so you see that jury, and you're like, oh, juror number 10, I did not like the way they answered that question. I'm out of strikes. What are we going to do?
Well, even worse than that, actually, is if you're like, the prosecutor's going to strike that person, don't worry about it, and then they don't. That's, or, if it's like, we haven't heard much from that person, I would just leave them. We'll never get to that person. The great unknown in jurors is definitely a concern, I think, on both sides.
So let's talk a little bit about the Court of Appeals decision. So the Court of Appeals makes that decision. They're saying, hey, you guys kind of messed up the process. You should have laid a better record. And by the way, you just can't skip over a juror. Defense, prosecutor, court, you got it wrong. We're going to reverse this case. How many people agree with that decision? Just by show of hands. We got 1, 2, 3, 4, 5. Means the murder conviction was vacated and it's going back to the trial court.
Okay.
So we got 1, 2, 3, 4.
Maybe.
Maybe, all right. Okay. We don't quite have half, but there's a good number of people who agree with the Court of Appeals decision. And let me be the first to tell you, congratulations, you're all wrong. No. So what happens is the Indiana Supreme Court actually accepted transfer on this case, and they took up that case, which does not happen very often. If you look at the number of cases that the Indiana Supreme Court actually takes a look at, it is a very, very small number. So everybody is entitled to a criminal appeal as a matter of right. So the Court of Appeals is a volume business. They do a ton of cases. They hear a ton of different things. The Supreme Court doesn't take on many cases, but they decided to take on this case. And ultimately, what the Supreme Court decided was you, defense, agreed to this. And some would suggest it was even your idea. And the client was on the record as saying that's what they wanted. That they were not only okay with the process, but they wanted it. And so what the Supreme Court said is basically this is invited error. Meaning, was the process perfect? No, it was not. But you agreed to it. And you are bound by what you agreed to. And what you agreed to was, we should excuse this juror. We're going to skip over the juror, the first alternate, and go to the second. And the Indiana Supreme Court said that although the process may have been flawed, that because you agreed to it and you invited the error, that therefore you don't get the remedy of the conviction being vacated. Now, how many people agree with the Indiana Supreme Court? Not quite everybody. All right. All right, we got some dissenters here. I like that. This will be a fruitful discussion for all of us. Criminal defense attorney, you've kind of seen it both ways. How do you feel about the court's perspective on this issue?
I don't think there's much in the way of case law, probably not in this area, I would assume. You know, you didn't get the appeal, it sucks, but I mean, I think it is the right call just based on the circumstances. But again, it's a call that I definitely would have most likely made, you know, just in this situation. I would say I agree with it.
And kind of just so everybody knows, is you are basically limited or stuck with what you argue at the trial court level. You don't get to make stuff up on the appellate court or advance maybe different arguments than what you did at the trial court. And so a lot of times you are bound by what happened at the trial court. And I know one of the things that you as a defense attorney are constantly thinking about is that appellate record.
Yeah.
And I need to make a record on this issue. Can you talk a little bit about, like, when you are going to trial, preserving issues for appeal? What does that mean, and how do you preserve a given issue for appeal? Because if you don't raise it at the trial court level, very oftentimes it's waived, meaning you cannot raise it on appeal. So there's a lot of pressure on defense attorneys.
Yeah.
And so walk me through preserving that issue for appeal. How does that look?
Well, I mean, it depends on the issue. For instance, if we're saying that the police shouldn't have gotten to a piece of evidence, and we do a suppression hearing. If we, lose the suppression hearing, like pre-trial, essentially what you have to do is you have to go to trial and preserve that issue, at trial in order for it to be appealed. You can go to trial and not raise that issue at the time, and if you do that, you can waive your appeal right then. So it's kind of I guess the best way to describe it is you gotta kind of you gotta be on your toes. I mean, it's probably the best way to put it. Like for your suppression hearing, you would have to object at the moment that the state's going to put in the evidence that you think shouldn't have come in. If it's a jury issue, you have to raise it then and there. I would say most of the objections you need to make have to be contemporaneous, or at the time. You can't kind of wait and then kind of bring up an issue later because it potentially can be waived. So again, you kind of have to be on your toes and listening out for certain things. Obviously, you don't want to panic. Like if you hear something like the state has a witness who said something that shouldn't have come in, you don't want to get angry, you don't want to get upset. You kind of want to calm down first because you don't want the jury to see you upset. You say something like, "Judge, may we approach?" And then you go and talk to the judge about the issue with the prosecutor and say, "Judge, here's the issue here. I think this shouldn't have come in." And then you kind of go from there, whether you're going to ask for a mistrial or you're just going to have the jury admonished about the evidence or whatever. I guess there's also, that's kind of the main process, if you will. If you, I had an idea in my brain and it just escaped me. Sorry, I definitely have not been talking on the microphone. I feel like I'm loud anyway. But yeah, you got to be on your toes. You don't want an issue to get away from you, and then your client doesn't have a viable issue for appeal. That is definitely a major concern for defense attorneys, because if it's gone, it's gone, and then you have that whole PCR thing that Ryan talked about earlier.
And so I guess generally speaking, 30,000 feet. How do you feel about that rule in general? That if you agree to it or if you don't raise it, you have waived it. Is that too harsh, or is that the way you think it needs to be for the system to work?
I mean, it probably depends on the issue. You have fundamental error. If the error is just that, that egregious, that could save you. That's a long shot for a lot of times. I mean, I don't like it necessarily for younger attorneys, but I think if you've been around, and it's kind of a thing you should probably know, it probably is fair. That doesn't necessarily save you from the PCR route. So the client may have some avenues from that standpoint of things. But I think it's tough, but it's fair.
Tough but fair describes our public defender. Josh Berger, give it up for him. I see our moderator in the back is going to work the room, and does anybody have any questions? And we'll make sure we get those questions repeated with the microphone so they are picked up on channel. Why don't we start? We ignored the front last time, so let's make sure we get question right. First question right here up front.
How often would you have a trial where a juror decided, I can't do this? Does that happen very often?
It does.
It does?
And a lot of times it happens for, reasons. Life happens. I mean, people are regular people. Someone gets into a car accident, they can't make it. Someone's kids get sick, they can't make it. Sometimes the group dynamics are such that people are like, I can't do this, I'm out. And that doesn't happen nearly as often, but there's a reason you have alternate jurors is because we are going to need them. Two of the murder cases that we have going this week are going to be probably 6 or 7 day trials. In a 6 or 7 day trial, there's a lot of things that could happen, and so when those issues arise, you are going to rely on your alternate juror. I don't think it happens in every trial, but it certainly happens semi-regularly. I don't know what your experience is.
You're actually down a juror in one of the cases now.
Yes.
Yeah. Actually, I've had both ways. I've had jurors who want to leave. I've also had other jurors who've wanted to kick a juror off of a jury. We get a note from the jurors like, can we kick off this juror who's being rude and refusing to deliberate? And I was like, what? Ultimately, we did not kick her off, and they hung. But again, that kind of goes to that group dynamic thing. I've definitely had jurors who are saying they don't want to be here, or they get sick, or things like that. So alternates are definitely a key part of the process, even though they don't get to deliberate in the end if they don't get called on.
Any other questions?
I've been on prospective juries several times, and in the questionnaire, it's come up that I have actually witnessed homicide many years before for 3 defendants, and 2 of those were sentenced to death. I never knew why I was struck, other than the attorneys kept asking questions of me, and I think, let me go. But I never knew their reasons, other than I expected eventually they'd come around to say, you're excused. So is that an option for the judge to decide? Or I've never heard why any of us were excused.
Yeah. So it depends on the courtroom. That is most likely a peremptory challenge, where either the state or the defense are like, that experience is such that we don't want this person on the jury. And so I'm guessing someone is exercising their peremptory challenge to say, hey, whether it's the state or defense, say we don't maybe necessarily think you're the best fit for a jury moving forward. Well, what would you do in that circumstance?
Well, I mean, it would depend on what kind of case it was, but
it's a murder case.
It's a murder case. Well, I would probably lean in and ask you about your experience. It would depend on what the evidence is that we have to work with in that particular case. And I would ask you potentially, in those cases, what was it? What was there good evidence? What was the were there witnesses? Was there evidence? I would probably lean into that. And if you say something that is the opposite of what we have, I might not strike you because you have experience in that type of case, and you might have been guilty, but it's because there was overwhelming evidence of this one particular thing. It just depends really. I would tell you a lot of defense attorneys and probably prosecutors will be kind of squeamish because you have had that experience. But again, I probably lean into it because maybe what you have to say again is the opposite of what our case is. So, and that obviously is good for us.
Well, we haven't got anybody from this side. Let's get this side.
Okay.
So as a person of color, I do show up to my jury summons, but I've never even gotten a questionnaire. What does that mean for individuals when they don't even get to that area and we're still in the room just waiting for hours, and then they're like, bye, we don't need you anymore?
Man, you are showing up on the right day. Yeah, that's so basically the process works. So let's say we've got 5 trial, like Mondays are our big trial day. And so the judges will tell jury pool, they'll say, we've got 5 juries going on Monday. We need 50 people per trial, so that's 250 people. If you want to get 250 people, we need to send out summonses for 700 for them to show up, okay? And so I'm guessing what happened on the day that you showed up, a lot of times cases get resolved morning of. And so if you're number 200, and instead of 5 trials going, we only have 2, they're gonna cut everybody loose. That's, number 150 through 250 is what is happening when you show up. So you are assigned a number, and then that number kind of determines whether or not you get to sit in the box and fill out the questionnaire and go through all of that stuff.
I said you would just randomly not getting selected because it's random. It's not like they're like, oh, it's you, we're gonna put you at the end.
Right.
You're just a product of statistics, basically.
Yep.
Okay. Yeah. I would like to ask you if I had been selected at one time for being in the jury, and one of the reasons, the question that they asked me was something about health. And do you consider that, I suppose both mentally and physically or whatever, the health of the juror?
There are, I guess there's a section of the questionnaire that talks about, if you have any issues, like health-wise. I usually don't track people. That's not normally a consideration because the court can make accommodations for you. Like if you have hearing issues, they can move you up to the front. Vision issues, they can move you up to the front. So that's not a basis that I track people. As long as you say you can see things and read things, it doesn't matter to me. I mean, even some people have frequent bathroom breaks. I'm fine. The court will make accommodations for that. That's not something that I care about, quite frankly.
I had to have the doctor sign something for that.
Can
I ask a real quick one? Why is it taking so long for the Libby Abbey case? I know it's $1 million already. Does anybody have an answer?
Yeah.
That's so ridiculous.
Well, I think one of those things that you always have to remember, though, is, and the question was about the Delphi murder case, and it's really important to recognize that you had basically every police agency in the state of Indiana working on that. You had every federal agency working on that, and you never know what is going to be relevant to a jury. And so you got to present it all, and you got to say, this is what we did. Because defense is going to raise a number of things, including, I didn't do it. And so you want to be in a position to say whatever they ultimately argue at close in terms of why they think they didn't do it, you want to be able to point to evidence that refutes their argument. And so state police put in a ton of work, the sheriff put in a ton of work, the local police department did, the FBI did, all these different agencies worked really hard on this case. And so you don't know what the issue is going to be necessarily at trial. So you need to make sure that you present everything, so no matter what the defense attorney say, you can say, no, 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 no. We looked into that, we addressed that, and we can refute that. And so, you know, if you put, I mean, I don't think it's an exaggeration to say literally thousands of police officers working on a case, it's going to take a really long time to get through what they did.
Burden of persuasion is what he's getting at.
Oh, it's my favorite. We got a local celebrity here, so.
Sorry I came late. I wanted to ask why would a witness refuse to testify? I'm assuming because they worry about possible consequences. If that is the case, do we have any witness protection program locally, just like the federals have?
Okay. So first of all, great question. And yes, we're very fortunate. And one of the things that we frequently do is we are in a position to relocate people. And so if people need to move or get out of a particular area, we are able to do that. And we have the financial resources to do that, whether that's right before trial, when the case initially happens, you know, even before we're able to solve things, we have those resources. I also want to calibrate expectations. You're not moving to Arizona. Your new name is not going to be John Gotti, and you're not going to have a dummy job in a warehouse in Phoenix. We can't do that, but we do have the resources to help people address and deal with those situations. And, you know, for me as a prosecutor, you always want to be sensitive to people's concerns, because oftentimes those concerns are based on a reasonable belief. I can tell you that I have tried many homicide cases. I have never had a single issue with a witness. It just does not happen very frequently. That being said, I never want to be dismissive of anybody's concerns. I want to be there to help them and offer whatever resources they need. And we're very fortunate because we do have resources to offer help and protection if people want it. For the vast majority of times, I would say everybody is very respectful throughout the process. And so, you know, the other thing is, I guess the flip side of that coin is, our system is predicated upon people coming in to testify. Whether you think that's a good thing or a bad thing, we don't have a criminal justice system without it. The right to confront and cross-examine your witnesses is literally what this country was partially founded on. And so we have to have that. And the courts have to have a mechanism to say, hey, if we don't have this, our entire system breaks down. People are just like, whatever, I don't want to bother. It doesn't work. And so I'm someone who very much respects not only our judicial process, but the Constitution and what that stands for. And what that stands for is you have a right to cross-examine your witness. Take your best shot, cross-examine that witness. You deserve that opportunity. But at the same time, if we don't have that mandatory or compulsory process, then the whole system blows up. And it should be noted, not only the state has a compulsory process, but if you are a defendant, you can absolutely subpoena someone, and if they don't want to come in, you can make them come in. And with that, we are out of time. Do we have a t-shirt? Anybody, do we have a t-shirt that I can show or show off to people, since we're 2/3 of the way there? Nice. So we've got some models here with prior year t-shirts. I see we've got some other t-shirts right here. Is that third? What number is that? We got 8. Nice. We got all these. And then we've got our most recent one, and that's what we'll be handing out next week. Turn that around, looks good. There we go. So we look forward to give that to him for being such a great, yeah.
Has it been that long?
Yeah. So one more time, give it up for our panelists. I know traffic was rough getting here. Thank you everybody for doing it. I look forward to seeing everybody next week. Look forward to getting to pass out those t-shirts. And thank you once again for participating in the Community Justice Academy. We'll see everybody next Wednesday.